Welcome to Chaile Time, our weekly podcast whereby we touch base with the work-related matters. Toby, welcome.
Thank you, Tepo.
How you've been?
I've been busy this week, I'm telling you, yeah.
So what's been happening in your world out there when you're busy with your clients and your
there's a lot
cases?
of issues all the time. Also with you, I had a case, I concluded the case yesterday at the MEIBC, the Metal Engineering Industries Bargaining Council, arbitration. The employee, yes, some employees can take chances, Flip, I'm telling you. This person, he apparently impregnated the woman. Okay, now he's got personal issues. Right, so he's running away from his wife. Okay. Anyway, so now he wants to go to the Eastern Cape. He stayed away, for like 9 days, and the company sent messages and so forth. And eventually he came back after 9 days, and he said he no longer want to work there. Okay, it's a bit of a contentious issue. The company typed out a resignation letter. You know, these resignation letters. Do not type out a resignation letter. Give the person a piece of paper and say, write. And if they can't write in English, write in Zulu or Xhosa or whatever the language must be. But let the person
write on themselves.
Write themselves. Because we sat for probably like 2-3 months, 3 or 4 sit-downs with arbitration, and the biggest argument is this person did not resign because the company presented a typed resignation letter. But at the end of the day, we had 2 witnesses from the payroll and the HR department. They actually sat with him, explained to him in his own language, actually tried to convince him not to go. But he was adamant he wanted to go to the Eastern Cape because he's running away or whatever the case may be. But lo and behold, very surprisingly, 2-3 months later, now he's back. Now he files an unfair dismissal dispute at the CCMA, saying no, he was actually sick, and he provided a doctor's note, but it wasn't a doctor's note, it was a traditional healer's note. But what's interesting about this note is, and I've highlighted the fact that in arbitration, normally if a doctor book you off, they will do a consult, they'll diagnose you and say, listen, in my professional opinion, you must be booked off for the next 3 days if you have flu, or the next month or 2, whatever the case may be. Not this one. The day he filed for his arbitration case, which is actually condemnation because he was grossly out of time, the doctor's note was dated the same day as that he applied for condemnation, booking him off backwards. So this doctor said, no, I agree, you were supposed to be off the last 2-3 months, But interesting is the doctor's note also, or the traditional healer's note, was also not signed by the medical practitioner herself or himself. So so we concluded the case yesterday. And I had my last witness yesterday. It was actually the supervisor of this employee. But yes, he got so upset because he's sitting there blatantly lying, and the supervisor know him. But that employee can't look him in the eyes. Not at all, I'm telling you.
And what about the union? Or was the union there?
Yeah, there was.
I think I know what case you're talking about, because there was a rescission somewhere there.
Let us not go. I've seen some funny characters over the years. This guy is an old toppy. But yes, it's difficult. Oh my goodness. Part of the reason why the case took 3 months is because most of the time this union man was fighting with the commissioner. And most of the time he didn't have his documents, his bundles, his evidence, and he didn't understand. I don't know how he became a union official. He didn't understand he was supposed to print his own documents and bring it with. In his mind, he emailed it to the bargaining council so they have it now. But he was just arguing and fighting. He was a very difficult man to deal with. But anyway, we're done. So I'm looking forward to some time off this weekend.
Okay. What a week you had.
And yourself?
Actually, I've learned a thing or two in the past 2 weeks. That the council, sometimes you just have to leave your gloves in the office when you go to the council, because you just go there and you settle.
Okay.
You don't fight, because normally we prepare, we have 16 bundles, we have this.
This is the conciliation you had.
Yes, but I had another one last week.
Oh, is the other one, yeah?
Yeah, I had another one last week at the Road Freight Bargaining Council.
Oh, what? I can't remember that case. What happened there?
Yeah, that's when I settled for 2 months.
Oh, yes.
With the driver who was like above 72 years of age and stuff.
Oh, the person was dismissed for being too old or something.
Yeah, something like that. So, walked in there, greeted the union officials with a smile, I'm like, to the commissioner, but I'm here to solve the matter. So now I've learned that not always when you go to the council, you have to take your gloves. Even yesterday, we went to actually resolve some issues. So the 2 weeks that I had, it was not
Yeah, but you were quite smooth yesterday. The union didn't say anything.
nothing.
It was just Mr. Kanama.
100%.
Anyway.
Yes.
Yeah.
So what are we touching base on this week?
One of the most common elements of misconduct in the workplace is dishonest staff. Now, over the years, I've been in IR probably for about 20 years, and this is the one thing that just keeps on, it amazes me. To what extent employees in South Africa are crooked, man. Now, obviously not everybody. It's a generalization, huge generalization. I get it. We're not all crooked. I think we are all crooked.
You know what?
I think we are all.
You know what's the best for me?
Everyone is crooked. Every employee is crooked, period.
You know what's the best for me?
What?
Knowing that you've done something wrong, but still go to open a case at the CCMA or the bargaining council.
I'm telling you, you will steal from the employer, and the day he fires, you're on your way to the bargaining council or CCMA to open a case.
So I always tell people that as soon as, I postponed a case last week because an employee was issued a notice a day before the hearing.
Okay.
Then I stopped there and there. I chaired a hearing, but I stopped. I said, you know what? I'm going to give you an extra day so that you can go and prepare enough time so that when you come, you are ready. And the lady, the alleged offender, was like, no, it's fine, I'm ready. I'm like, no, I'm not going to take that.
Arbitration is de novo. It means it's a fresh, it's a new case.
Yes.
They find now, but come arbitration, I made a joke with somebody this morning. I think I was on a Harmony WhatsApp group or something, Employees are uneducated sometimes and they're ignorant in a hearing. But when it comes, then they get dismissed and they plead guilty in the hearing. Ne?
They become superhuman.
But they become superhuman at arbitration. Suddenly they're having a Google law degree.
Yeah.
And then they're not guilty. And then suddenly the time was not enough.
Exactly. So they get advices from other people as soon as they walk out of the workplace. Some advices are wrong because people think the council is a cash cow.
Yeah.
You go to the council, they will pay you. Go. Even if you stole, no, go. They must pay you. So that's the mentality that's running around.
No, I must just clarify myself, I think all of us, I suppose you get white and blue collar crime out there, I think we all at some stage take something for granted. Maybe a phone call that doesn't, it's not your phone, or you use the company's internet or laptop resources for your private use, just to print your child's task or whatever the case may be. So in a way we all do it. But look, at the end of the day, what I want to talk about today is that, there's also an element of gross dishonesty where staff are committing fraud and stealing from the employers. And you know what now, is that, I don't know if it's a mindset or what it is, but often employees, they think they don't even know that what they're doing is wrong. They sort of think it's their right to steal from the employer. And I was sometimes in a distant hearing or charging the person, maybe got charged for dishonesty, he stole money, and now I find him guilty and a sanction of dismissal. But then I will sit afterwards, just when I concluded the process, and listen, sir, if you want to move forward in life, or ma'am, you have to look yourself in the mirror and say, listen, I'm a thief. I stole from my employer. I didn't borrow anything. I stole. You will never go or move forward if you don't get to that point where you realize, I stole. You're a thief.
Yeah. But it's not that easy. People are in denial out there.
Look, I understand the context of poverty and so forth. So there are many elements to why people steal. I get that. I'm not dealing with labor relations.
Yes.
There's a fiduciary duty between an employer and employee. That means a duty of good faith and trust between the parties. I suppose in our engagement with one another as citizens, you can't build a society if we don't trust each other.
Yeah.
If we steal from each other, no society can actually operate that way. No business can operate that way. So, but anyway, sometimes employees don't understand that what they're actually doing is wrong. I had this case recently. I represented an employee. It was at the CCMA in Pretoria about 3 weeks ago. And this person was dismissed for dishonesty because in her application into this company to work there, the employer actually negotiated a salary with her via WhatsApp. And he pertinently asked her what was her current salary. And she overstated her salary by 2,000 Rand. And then also still pitched for another additional 2,000 Rand. So she earned, a new salary was 4,000 Rand more, was extra to what she currently earned. Now, in principle, negotiation is fine. There's nothing wrong with that. But if you negotiate on the premise of dishonesty, where you actually cheated and lied to your prospective employer, that's an issue. Now, I got the WhatsApps here, and you know what's surprising? She did went to the CCMA, and I had to represent her, and I explained to her, okay, you were taking on this case, but just remember, you're not right. You can't lie to an employer and then expect to get away with it. Okay, so obviously, when you go to a CCMA, there's always a possibility of a settlement. In this case, they actually did settle on 2 months' salary. So I shouldn't say that too loud, because that's probably why employees, when they're dishonest, they still go to the CCMA, because they know about this settlement thing. No. So anyway, so they still go and take their chances. Because employers often don't want to be tangled up in lengthy legal disputes. It takes sometimes months to go through arbitration, and thereafter maybe a review application, the labor court, another 2-3 years, whatever the case may be. So in this WhatsApp, the employer asked, don't you want to let me know what your current pay is? Because I want to know what package I can propose to you. And then she started laughing, hehe. Currently, I'm getting 16,000 Rand a month, and I will work for you for 18,000 Rand a month. He actually did agree to the 18,000 Rand, but now the employer didn't ask for the payslip. But now, in preparation for arbitration, we realized that she was only earning 14,000, not the 16 she said. So that's dishonesty, So if an employer finds this out, the whole employment is based on a lie.
Can they still trust each other going forward?
Well, the employee was very opportunistic. So how do you trust the employee like that?
My point exactly. So it clearly shows. Actually, it reminds me of this other one whereby an employee was asked if they have their own car, because like in our business where we drive every day, and then driving is needed, and then applied for a job, and then they asked, do you have your own car? And then the person said, yes, I have my own car. But on the day when they start working, they claim that their car is in an accident somewhere, but the company was lenient. But 3 months down the line, actually the company discovered that this person never owned a car. So I think the person wanted to earn the salary in the next 3 months so that they can afford to buy a new car. But things didn't go according to plan. The person was caught out, you see. Now that's also...
I had a case this morning. This employee applied for a job at the company. And part of the rules of this company is that they don't employ employees who used to work there previously. So this employee did work at this company or in the group previously, but he was dismissed for fraud many years ago. So now he reapplied for a position there. But in his CV, he removed the part where he worked for that company historically and put some other detail in there. Also, in the application process, I asked him to disclose in writing where they used to work for a company in this group, and he said no. Table. Now that they employed him and found out, he blames HR for not doing a due diligence. They should have verified with his detail and found him out. But he's the criminal, you see.
In my days during the logistics time, they have a brilliant system there. One driver once lied there. So I did a test. He was fantastic. He passed everything. I took his ID number, went and typed in there because I wanted to capture his details on the system. But it kicked his ID number and said this person was dismissed in 2018. So just before I employ him, I found out. So
Yeah, but you now did the due diligence. You actually went to check.
yeah, I didn't do the due diligence. I was about to.
But now I want to ask you, can a criminal justify himself for breaking into my house just because I don't have a wall around my yard? Oh, it's too easy to break in, therefore it's fine if I break in.
No.
So the criminal can't blame me. He mustn't break in.
So the person wasn't supposed to apply because
He wasn't supposed. No, he can apply, but you're supposed to be honest. Yeah,
Yeah,
you're
I
supposed
used
to
to work
say,
here.
"I used to work here. I was dismissed for dishonesty or fraud or whatever the case may be."
So this dishonesty, it's broad.
Dishonesty is broad. Everybody's trying to be opportunistic to get an edge and an advantage over the other people, you know. So, but anyway, there's the amendment to the National Qualifications Framework Amendment Act in 2019. Employees, you need to listen here. It's a criminal offense if you misrepresent your qualifications. Not only will your employer dismiss you, they can actually open a criminal case against you. It's a criminal offense to misrepresent your qualifications in your CV, but also other platforms like social media platforms like Facebook and LinkedIn or whatever the case may be. If you misrepresent your qualifications, it's actually now a criminal offense. So you should think properly.
Is this the reason why we've been changing mayors in Tshwane and Joburg? But we're not there. We are on their labor relations.
Focus. I suppose you didn't hear that. So we don't talk politics, we talk labor law now. Listen, long time ago, we both used to work for cinemas. We won't say the cinema name. Do you remember that? What? Zazaza.
Zazazo. Yeah.
Zazazo. Can you remember? What is it? Overcharge, no?
It's overcharging and then recycling and
Yeah.
there was every day is a new trick.
Yeah, if you-
reprinting of credit card slips.
Yeah, if you go to the cinema, né, to the movie to watch a movie, a popcorn, I don't know, maybe it costs $20, né? But they will charge you $25. They will overcharge, not give you a slip, you see. So then you as a customer, you're fast asleep, you know, but he's actually overcharging you. Also on the credit card machines, do you remember every transaction's got a transaction number?
Yes.
So let's say it's 1, 2, 3, 4 as an example now. So they will sell it to you, no problem. 3 hours later, they will just reprint 1, 2, 3, 4. Let's say it was 100 Rand. They'll put that credit card slip in the cash up and they will take the 100 Rand cash for themselves, you see. So at the end of the shift, when the manager catches up, they just count all the credit card slips, all the cash and everything balances.
So it was a seasonal thing. There was a season of recycling whereby a cleaner will get those dirty, empty popcorn boxes and then give them to a cashier. A cashier will resell them, and then they will take the money into their own pocket for their own benefit. But we struggled during the cinema times. It was a serious struggle.
Yeah, the cinema industry is a difficult one. People, sure. Anyway, so I want to highlight the case law here. That sort of shows the labor court's thinking in terms of staff getting dismissed. Employee, you must listen now. Because I'm telling you, if you are caught stealing or are dismissed for dishonesty, your chances at the CCMA or the bargaining council is almost zero. If you try your luck, you might get a settlement, but settlement on dishonesty charges now,
You keep on bringing that word settlement, and now you're giving people ideas that
I
there's a
shouldn't do
word
that.
called settlement.
Now we can have another Chaile time about the procedures and the processes at the CCMA. But if you think you can go for arbitration and win a dishonesty case, you'll be surprised. Let me read this case law for you. It's just a excerpt. In De Beers Consolidated Mines Limited or Ltd versus CCMA and others, the Labour Court found the following in terms of risk management. Okay. Dismissal is not an expression of moral outrage, much less is it an act of vengeance. It is or should be a sensible operational response to risk management in a particular enterprise. That is why supermarket self-packers who steal small items are routinely dismissed. Their dismissal has little to do with society's moral opprobrium of a minor theft. It has everything to do with the operational requirements of the employer's enterprise. So if it can be shown that you were dismissed for dishonesty, your chance of success at the CCMA, basically zero.
The very same, from the retail side now, the very same person that I postponed the hearing because she was given a notice today and the hearing was the next day. She went to a doctor, she was sick, proper. The doctor gave her 3 days. On the doctor's note, it was written she's off from the 16th, I think from the 14th to the 16th. But on the 16th, she took a blue pen on top of a black pen and wrote 9. And she only came back to work on the 19th. I was so defeated. And then when you sit there, it's an old lady. She's been working for the business for a long time. And you ask her and she's like, yeah, no, I did it. So those kind of things, dishonesty, it's really bad. It's not good for
There's another case law that says that no amount of mitigating factors can mitigate against an employee being dismissed for or charged for dishonesty. Dishonesty tarnishes the trust relationship. Also, Edcon versus Palmer, for instance, where it sort of was alluded to that an employer must motivate or justify or lead evidence to why a trust relationship is tarnished. The courts have moved on since then. It's sort of, there are certain misconducts and offenses in the workplace where a tarnished trust relationship, it is implied. And dishonesty is one of those things. But I want to ask you quickly. Now let's see if you can answer this one right. Are you ready?
Yes.
Why should an employee not be dishonest in the workplace?
Because it is the employees, they must, that word fiduciary duty, it's very important. They must always show goodwill towards their employees. That's my answer.
No, man, Sepo, that's a wrong answer. You know why we shouldn't steal or why we shouldn't be dishonest? Because it's wrong.
But they must always show goodwill.
It's wrong, man.
Yeah, it's wrong. I know it's wrong.
Many times in my life, I will do interviews for staff, and I always ask this question, do you steal? No. I ask, why not? You know what they say? I'm scared to be caught. Or I'll go to jail or whatever. And I tell them, man, you don't not steal because you're scared you're getting caught out. You can't be dishonest because it's wrong, man. Hey? Where is our morals? It's wrong to steal. But you're also partly right, but there are some other the consequences can be severe. Like for instance, if you're in the financial sector, if you've been dismissed for dishonesty, they have what they call the RAIDS list. If you are listed on that list. Now, apparently a lot of companies or most companies in the financial industry, they have access to this list and they will do a verification on this list. If you've been dismissed at any company in the financial industry for dishonesty, they will simply not employ you. So
I think I remember that with one of our clients in KZN that we had there. They said, because now they have to blacklist the person or red list the person.
They red list the person, So if you're in the financial industry, and you must think twice. If they catch you out, your days are cooked in that industry. And also something staff don't always know is that arbitration, you think you're going to go to the CCMA and take the employer to task. Now, the fact of the matter is arbitration is with prejudice. That means whatever is in that arbitration award can be used against you. Now, if you are dishonest and dismissed for dishonesty, and you think you're going to sort out your employer at arbitration, you must think again. Because whenever, first of all, that employer can circulate it on social media or wherever. It's public knowledge. Yeah. I see a lot on LinkedIn, people in our industry, we share arbitration awards to learn from it. So we see what Jan is doing. And verification agencies, they verify with employers, and employers will phone the previous employers and listen, why did the person leave? Don't worry, here's arbitration award.
Actually, you're correct. Even the case laws that you're quoting now, it's public knowledge.
Yeah, I'm talking about here the BS Consolidated Minds.
Like that
it's public knowledge.
That Situmo case that this SB was very famous in the few past.
Everybody knows Situmo Banya. Yeah, so you must be very careful before you decide you're going to take on. I had a case also on dishonesty a few years ago. This engineer, it was alleged that he stole equipment from the employer, and they opened a criminal case against him. I helped him at the CCMA. But when we came there, the commissioner also told him, listen, are you sure you want to proceed? Because whatever comes out in this result, they're going to use against you in the criminal case. I did the same thing about a month ago, also at the CCMA Pretoria. This person was trading in 300,000 rand illicit gold. Yeah. So I looked the guy in the eye and I said, listen, I will use this arbitration award against you in your criminal case. He actually did withdraw the case. I didn't play, ek het nie doekies omgedraai nie. And then there's obviously the last thing, and I think also from a communal perspective, as South Africans and employees, we don't always appreciate this. You know, employers are actually forming a distrust with employees. And I see this a lot. A lot of employers are trying to move away from actually employing people. They'll rather outsource, you know, because employees, when they come, you don't know what's going to walk in through the door, you know. They go on Google, they study your company, and they seem to be so smart, and they are well-dressed and neat and speak well, and they come here, they've got the qualifications, only later to find out that they can't do the work, they're not qualified, they're relying on the CV. So employers are distrusting employees, you know. So employers are asking, should I not rather outsource this function
and take responsibility
to another company?
To someone
because
else.
then I don't have, you know, all these labor law and CCMA issues. And it's a consequence because of the way the South African labor market is positioning itself. We can't be trusted, man. Anyway, that's all I have to say today. Dishonesty.
Dishonesty, the answer to that why you mustn't be dishonest. It's wrong. That's the answer.
That's the answer.
Thanks for watching. See you next time. Ciao.
Bye-bye.